Well, welcome to our seminar. My name is David Pike. I've gotten to talk to or meet most of you. I know some of you personally. And our goal of our law firm, which does probate, guardianship, estate planning work, is to take out fear and unpredictability through the process. And that's part of what we're doing tonight with this seminar, is to give you enough information so that you're comfortable with your estate plan, and if you come in for a consultation, that you have context to understand the advice that you're receiving so it makes sense. So you feel comfortable with that and you know you're making a well-informed decision instead of feeling like you rush into a decision in a brief consultation with an attorney. So we are on the path to good financial stewardship. That's the goal of what we're doing here. And as you can see, it's a fairly long path, and in the far distance up there, the goal is to have a properly planned estate. But as you can see, there's a lot of ground to cover before we get there. So we're going to back up to the very beginning, and here's our agenda. I'm going to first talk about what I call the Pike family of firms and explain that. And then we're going to talk about what is an estate, what is it that constitutes an estate, and here's a tough question: do you need an estate plan? And just to guess what an estate planning attorney is going to say to that question. I'm sure that's really tough. Then we're going to look at the issues and problems in an unplanned or poorly planned estate by looking at a case study of a mythical couple, John and Jane Jones. Look at their planning options and the issues they face. Then we'll take a break, stretch our legs, get some cookies, come back, and look at the solutions to the problems that we've identified in the first half and how we can solve those with a well-drafted will, a living trust, and look at other issues that come down concerning long-term care, powers of attorney. Finally, we'll talk about choosing an attorney, that if you choose us, what our fees will be, and then give time for questions and answers. So that's our agenda. So basic ground rules. The folder that we gave you includes a blue evaluation form, which I know my daughter's already asked you to turn back in. Most of the rest of the handouts are kind of for take home. This is not the type of seminar where I'm going to say, well, turn to your packet and let's read together from page 6, because that's really boring. Now, the packet of the large planning document in there is really informative. I'm proud of the work I did with it. So I encourage you to read it. It does have places for notes. If you're a note taker, you can take notes on the back page, but you don't need to follow along. It's really to prod you. If there's something I talk about that after you get home and you're talking about it among yourselves, you say there's something I didn't understand, that's further reading material that you may help you answer those questions or ask better questions when we have a consultation. There's a pink form in there that will talk about our services, and we'll get to the very end. And of course, silence your cell phones, at which point I always double check mine. Okay, and I'm turned off this time. So let's begin. Who am I? I am been an attorney now, I hate to admit it, for more than 30 years. I started working for a very large law firm and then was with a smaller law firm in the 90s and have been on my own since 2000. When I say my own, I'm the owner of the company. There are now 4 attorneys in my firm and 4 support personnel. And from 2000, we've concentrated the practice on probate, guardianship, and estate planning. And those may not sound like the same thing, but they are the same area of practice. And we'll talk about all of those areas as part of this presentation. I'm proud that I graduated from SMU Law School as a cum laude graduate in 1986. Before that, I went to Baylor University. I graduated magna cum laude and was an accounting major and passed the CPA exam when I was still an undergraduate student, and decided that really my career was not in accounting, that I would branch out from the family business, which is accounting, and actually become a lawyer. So the rest of the family, including various uncles, cousins, and other distant relatives, are accountants, which has taught me, they remind me all the time that there's a difference between accountants and lawyers. And that is that accountants understand that they're boring. So I can actually talk for the next hour and a half to 2 hours, and I think it's all scintillating. Now this is where you are, and obviously you found the building. Our office, of course, is just upstairs in this building, so it's convenient that we have this space down here for these presentations. So the Pike family of firms is a team. What you need as a client to deal with estate planning or wealth planning in more general terms is a team that works for you. So I'm going to describe this team, but there are other teams that you can have. So as the client of the center of the team, you need someone, of course, to prepare your estate planning documents. And I know it's all confusing because we have these names Pike. But Pike & Associates is my firm, that's my law firm, and so we would do estate planning and guide you through probate and guardianship if that's necessary. I work with my cousin, who's also named Pike, who's in Georgia, and his company is Stewardship Financial. What they do is do actual money management, where they place investments and recommend portfolio adjustments for people. The Pike & Pike is my father and brother's accounting firm. My brother is the active partner at this point. His name is Charles, and he is both a CPA and a certified financial planner. So if he would be the one to deal with people directly one-to-one to coordinate with Stewardship Financial for people's investments. So what we're doing is coordinating 5 key areas of your financial world. One of it's estate planning. Second part is asset protection or risk management, which is both a legal and an insurance issue, depending what the risk is. So there are things that we can do as lawyers to protect your assets and sometimes appropriate insurance. Nobody in our team sells insurance. We would refer those people to, refer good insurance people to you if we thought it was necessary. 2 of the components of this are really investment planning, retirement income planning and investment planning themselves, and the final is tax planning. So those are the 5 areas that the team looks at to make sure you're on a path to good financial stewardship. Because having a good estate plan is a great idea, but it's better to have a good estate, that everything works out right. And if you ignore one or more of these areas, even if the documents I draft for you are really great, if they don't fit with everything else you're doing, you don't have a good estate. You just have some nice, pretty estate planning documents, and we want more than that. So all of these areas work one into another. I'll just give you an example, and it's a fluid circle. You don't necessarily start at one point. But to know how to do investment planning, you have to know what your retirement income sources are. What can you do with your investments? How conservative do you have to be with your investments? Do you have a pension? Do you have other guaranteed income that's going to provide you retirement income other than your investments? You don't want to lose an unnecessary part of that to taxes, and if you are, then you have to do your planning differently. You want to make sure the assets that you have, that you don't lose to unnecessary risk. Unnecessary risk is often that you're in rental property, and as you know, whatever you do, here's someone who knows a little bit about rental property, whatever you do, you can get sued, right, Rochelle? And so it doesn't matter how good you do your job, that has risk associated with it. Or you're in a business that's risky. Nothing is riskier than being like a physician. Doesn't matter how good they are, bad things can happen. So you want risk and asset protection planning. And that folds into estate planning, which folds back into investment planning. It's just a circle. One thing leads to another. Because we all have 3 major concerns when it comes to money. We want to make sure that we're not going to run out of money. That's the worst scenario. Really what we want is to be able to live until the end with a lifestyle that we desire. That's effective planning. And related to money and also other issues is that you are not a physical or financial burden to your dependents, your family, your children. So we want to do effective planning in all these ways to make sure that those needs are met. So a stewardship plan is part an estate plan and part a financial plan. By coming to this consultation, by coming to this seminar, we offer you a free 1-hour consultation with our law firm to look at an estate plan, and that's really what we're going to talk about tonight. But you also, after that, have the right to have a financial checkup with Pike and Pike, and my brother in particular, to look at these other issues and see if your financial life is in order, so that we're looking at the entire wealth strategy plan. So as a client of our firms, we will help you build a plan to implement and incorporate the purpose for your wealth. It's great to have money, but money should serve us, not the other way. So people like this approach because a lot of times in a couple, well, almost always, there's a level of divide and conquer. Things are done by one spouse or the other, and maybe they don't have equal knowledge. Despite the fact that I have an accounting degree, I married a tax accountant. So who handles the tax stuff in our family? Not me. She outranks me by a master's degree in that regard. So I deal more with the investment in our family. But if you aren't, we want to make sure both members of the family are well educated, they know the plan, so there can be a transition when the time is necessary, because there's going to be a time when one of us has to do a job that we don't want to do. And if I have to take over the tax part, I'll go, but that's why I went to law school, well, so I wouldn't have to do that. So the important point is not that you necessarily use our family of firms, but that you have a strategy. You have people that form a team to look after all of these areas. And we, as lawyers, want to work with your team, whatever it is, to achieve your goals so that all of these areas are met and interwork together. But we're here tonight to talk about estate planning. That's what we're going to talk about. And I say congratulations for coming. Why? Because you're about to hear the smartest estate planning in the world give you a great presentation. That's really not the reason. The reason is you're taking a big step to put yourself on the path to good financial stewardship. Because what is the number one reason that people don't have a good estate plan? They're afraid of it, and therefore they procrastinate. And so you have started the process to say, I'm going to get educated in this area and I'm going to work to solve this problem. And the second problem is a lack of knowledge. They're afraid of it because they don't know enough about it, and it's scary to get thrown in with an attorney, and especially if he starts throwing in terms like a living trust and, advance directive, and what's he talking about? Okay, so we're going to try to solve. You've solved the procrastination problem by getting here tonight. We're going to try to solve the knowledge problem. And then we're going to try to keep you from procrastinating. We're going to try to make you deal with this issue. We can't make you, but we're going to try. So what's an estate? What's an estate? It's all your assets. Every once in a while someone says, well, it's your home. And it's like, well, that's because you live in Tara. If you have Tara, that's your estate, right? But it is your home, but it's every form of asset. It can be financial assets. Obviously, it's your car, the cash in the bank, and investments that you have. And some people are familiar with the term probate asset. Anybody know that other than the lawyer in the room? And a probate asset, the CPA knows it too. Okay, a probate asset is an asset that is transferred by the probate process, but they're non-probate assets. They're important to our planning too, even though they may not be transferred by the will. Examples of non-probate assets are the IRA, a 401k, a 403b, that's kind of the government version of a 401k, pensions, annuities, life insurance, and various stock savings accounts. These may be non-probate assets, but they're part of your estate plan. So we're interested in how you hold your assets and whether we need to change the beneficiary of those assets to make sure your whole plan works together. And then we can keep going on and on. You can have intangible property rights like copyrights, intellectual property on technology rights, jewelry obviously. If you own the Rembrandt on your wall, that's a kind of important asset to deal with. So it's everything. Guns. Why don't I show a picture of a gun up there? Guns have a unique issue to them. If you have a gun collection that requires a license, that is not every type of gun. My gun collection is 2 shotguns. I don't need a license for that. If you need a license to transfer guns, you have a particular estate planning issue that I'm not going to discuss tonight. You just need to discuss it with us when we talk about it, if that's your situation. So that's an estate. Here's the problem. We don't want you to be the target for the lawyers and the IRS and the courts when you die. And if you don't do things right, that's what will happen. So we don't want you to be worth more dead than alive. So do you need an estate plan? Well, of course you need an estate plan, unless you just want the government to pick it for you. If you don't do anything, there's what we call the rules of descent and distribution, or intestacy. In other words, there's kind of a will that's already written for you, and that's what you get. But it can be very unfavorable. The worst common situation that we run into is you have let's in this example, all the examples we use, we kill the men first, so the guy always dies. So the husband has died, and he wants to leave his estate to his wife, but he didn't have a will, and he had children from a prior relationship. The homestead, does it go entirely to his spouse? No. In effect, she is in a partnership with the deceased husband's children. Is that a happy partnership? I haven't had a case yet that I consider that a happy partnership. One of them wants to live there and have a house. The other is just concerned with its future resale value. No one wants to spend money on the house today. It's a terrible situation. But that's what happens as a default. So the default law isn't very good. So you want an estate plan, so you're trying to answer some very basic issues. Who do you want to get the money to? That's usually pretty easy. We know who of our relatives or friends we want them get the money, with avoiding unnecessary delays and administration cost. You want them to get it when you want it. Well, you want them to wait? Don't you want to get it now? Isn't that the logical answer? I want it now. Isn't that what the TV commercial is? Well, there are some people that you don't want them to get the money now. They include minors, people who are disabled. If a child is contemplating or a divorce, for example, or you just have a reckless, maybe addicted personality that's your heir, to give them control of the money may be just in effect turning money over to their creditors or the people that are going to take advantage of them. So when you want is not necessarily right now, and that has to be considered. And then you want it to be handled by the person you want. There are a variety of roles that you can have in estate planning, whether we call it an agent under a power of attorney, or a trustee, or an executor, or an administrator. All of these positions require you to appoint someone you trust. If you don't trust them, you don't appoint them. So we have to identify those people that we have that level of trust in and appoint those to handle the problems. And obviously we want to do this at the least possible cost. If you want to maximize the money going to probate lawyers, you leave now, because that's how we make money. We make money not by planning, but by picking up the pieces when people didn't plan. So we're like the Fram oil filter guy. You can pay us now, or we're going to do the engine overhaul later. So what we're trying to do is get you on a path to minimize your total estate cost, because that's what you really want. And you do that by having a good plan that means that the money goes to your family, not to the courts, attorneys, or the IRS. That involves avoiding problems in at least 3 areas: guardianship, probate, and taxes. And we're going to deal with each of these issues. So before we do that, just talk a little bit about this. Is really a complex maze of legal issues. I am actually thankful that I did not begin my legal career as a estate planner, and that is not all I have done. because I got to see all of these other areas of law and how they interact. And as someone who's litigated disputed estates, I see where things have gone wrong. I think that gives me a better perspective as a planner than people who haven't dealt with the problems. And I can see the risk from creditors and civil lawsuits and tax issues, how they're going to attack somebody's property, and that how we're guarding not just a good estates plan. I know more than what is just in the Texas Estates Code. I know these other areas of law and understand how they can impact and destroy an estate in other ways and plan for it. So that's what we want to do. Now, to understand the issues I was talking about, guardianship, probate, and taxes, we're going to use a case study. We're going to have a couple, John and Jane Jones, and they're a really attractive couple. And we're going to say they have an estate that's $700,000, and they own it jointly. We are a community property state. If you're married for a long time and you didn't have an inheritance, probably most of the things you have are community property. And so we're just going to assume all of theirs is community property. To give you the short course in community property law takes about a semester in law school. That's the short course. So it's actually very complex, but it's a basic rule. So that means whatever they own 50-50. In doing both planning and dealing with probate estates, I have people come to me all the time. They say, yes, but that's her car and that's his car. And I say, no, that's half your car and that's half your car. And they go, no, no, no. The title is in her name or his name. The point of community property is, regardless of how you title it, if it's acquired during marriage, it's presumed to be community property. So it doesn't really matter how it's titled. You probably own it together, which causes people to overlook issues in planning. So in this case, we're going to assume they have $700,000. Now you may say, but I'm not married. I'm single, I'm widowed, I'm divorced, or I'm married more than once. All the issues we're going to talk about impact all of those other family relationships. Generally, if you're single, you're going to go through one step that we see instead of two steps, but you're going to have the same issues. So just for illustration purposes, we're going to just look at this couple, and I think we're going to see most of the issues. And they have two children. They have a lovely, responsible daughter named Susan, and they have a son named Timmy. And generally, there's usually a Timmy in every family. You know, in some way or some form, there's a Timmy. And we're going to talk later on about how Timmy creates special planning issues. So here's planning. They could spend it all, right? As we often joke, perfect estate planning is the final check bounces. Now, the problem with that plan is you have to know when you're going to die. You know, I mean, some of us have a goal of leaving property to our children, and that's different. I was filling out a survey to determine how my investment strategies, my wife and I were, about what's your goal? Don't tell my daughter, she's out there, but I'm going to get out, I'm sure she can't read my lips. And they ask, the level of importance 0 to 10 that you leave something to your children. And I said 0, and my wife was like 8. And I was like, really? Who cares about them? You know, so it depends what your goals are. I'm perfectly happy with spending it all, but I have this problem that I don't know how long I'm going to live. And the second part is die intestate. Intestate is what we're talking about, where the state has a will for you. And it fills in the own blank, but it may not be what you want. So there are 3 common options when you're really planning, when you're not just going to burn through the assets. There are joint tenancies, wills, and living trusts. And we're going to talk about the latter 2 in some detail. I'm not going to talk a lot about joint tenancy. And it goes by different names. You'll hear it as POD, payable on death, or joint ownership with right or survivorship. There's nothing wrong with those issues, but trying to patch that together in your assets to make an estate plan is difficult. It works for people that have a relatively simple family structure and a relatively simple issue. I generally only recommend it to someone that I say is on the glide path to a soft landing. In my meaning that they have probably lived a very long time, they are running out of assets. Often what they have left is a small bank account for which Social Security gets deposited and a home. And if they have a simple family structure, meaning they have like one child, then we can avoid probate and all these other documents by doing a joint tenancy. But there's no flexibility in those arrangements. You will see the way almost always you write a will is, well, if this, then that, if this, then that, if I'm survived by this, then this. And all that flexibility goes away in the joint tenancy arrangement. So it fits in some limited circumstances. It used to be much more difficult to do in Texas because we didn't have anything like right or survivorship deeds, but we do now. That's a fairly new addition by our legislature. So we can work that for some people. So the options we're principally going to be looking at is a will and a living trust. And most people understand a will, a living trust. We're going to give it a little bit more an explanation. So, but in John's case, John and Jane, they're make this checklist of the things that they're going to do, and one of them is to create a will. And John says, well, I met this guy at the health club, and he's a lawyer. He can draft a will for me. And he goes and asks him, he says, do you draft wills? He's like, well, I took a course in law school, so yeah, I can draft a will. And he has him draft a will. So he thinks he's got his planning done, and this is the will that he does. He says, everything to my surviving spouse, and for the last of us to die, we're going to divide it equally between Susan and Timmy. Great, all done. He's checked that off on his check box, and he goes back to his exercise program, and then what happens to him? He has a stroke. Okay, so what does the will say? The will says, when I die, my property goes to Jane. What's the problem? He's not dead. That's actually a problem. Did they plan for that? No, they didn't plan for it. It's actually fairly easy to plan for it. And we're going to talk about how easy it is to avoid this situation. But he doesn't plan, and now he's disabled, and he's not thought about this situation. Well, who will handle his financial affairs then? So, let's say she's got an account at, I always try to pick a defunct financial institution, and they merge so often I forget who's who. Does Paine Webber still exist? No. So he has an accountant. John has an accountant, his name at Paine Webber. Jane comes and knocks on the door at Paine Webber and says, John's dead, here's his death certificate, I need control of his account. What do they tell her? Go away. Or actually, he's not dead. I killed him. They're not supposed to kill him yet. We'll get to that. He's disabled. She cannot get control of that account because she's not on the account. And this is very common. I mean, spouses and couples run their lives entirely differently. Some of them want everybody on everything. My wife insisted for years that she be controlling the own checkbook because she was making all the money and I was going to law school, and she wanted to control the checkbook. And I walked into the bank and said, that's my money. They'd say, no, it's not. It's not my money. So even though it's community property, and it is, who is the title on the account depends who control it. So how do we fix that? You do it with guardianship. Guardianship is a necessary tool in the lawyer's toolkit, but it's akin to open heart surgery. You're glad that when you need open heart surgery, there's someone there that can do it for you, but you really wish you could handle this a different way. It's expensive and it's difficult. So what is it? What is it is court proceedings designed to protect those who are mentally disabled, and I should have pointed that out already. Even though we use a wheelchair there to indicate disability, I'm not talking about physical disability. Disability from a legal point of view is mental incapacity. That can be the result of a stroke. By far, in today's age, the most common form of mental incapacity is Alzheimer's. It's dementia-related Alzheimer's. It's far and away the most common thing we see. Now, why does a probate attorney deal with guardianship? Because the probate courts handle guardianship. And so it's all in our field of law. And there are a lot of overlaps in knowledge. So what's the problem with guardianship? It really is a nightmare. First of all, Jane has to go down to court and in a public way, in front of a judge, attorneys she doesn't know, tell the world that her husband is mentally incapacitated. That is not an easy thing to do. And once she becomes guardian, and it's likely that Jane in this scenario would be the guardian, not a given, but it's likely, she's not in control anymore. The court is in control. Yeah, I describe guardianship as a mother-may-I relationship. And this analogy works so much better because all of our probate judges in Dallas County are women. But you must go to the judge and say, Mother, may I? Mother, may I sell this property? Mother, may I spend this money? Mother, may I invest that money? And when you go to ask Mother for permission, who is with you? Your attorney. Good for me, bad for you. It's aggravating, it's expensive. So guardianship solves a problem. We are glad, and I mean literally, when my clients come in and they need guardianship and we tell them this is what we can do, they're happy. I mean, it is a necessary thing. It's not an evil thing, but it's not the best way to handle it. Okay, probate has its own issues, okay? Is probate evil? Who would vote that probate is an attorney-created shakedown? Be honest. You can tell me. No one's going to raise their hand on that? Okay. Guess what I say? No, it's not an attorney-created shakedown. Although we have a lot of good friends in the legislature that keep things cooking.
Especially in Dallas, where you got to have an attorney to do it.
You do. You're right. And it's not the only county that way. The courts interpret that it's practicing law without a license if you, because you're going to be in a representative capacity for the estate. So you can't go down and probate an estate without an attorney. Texas has great probate laws, actually. Texas is a great state to die or go broke in. We are a debtor haven. We protect debtors like crazy, and our probate laws are excellent. But we have to have probate. And the reason we have to have probate is during your lifetime, you want to sell your car. What do? You go into the dealer or whoever you're going to sell it to, you give them your ID, the title's in your name, you sign over the title, everything's good. Who's going to sign your title for you when you're dead? Well, the person who wants to buy your car or your home or whatever else from you has to know who they're dealing with. Otherwise, it's like a black market. Your assets are devalued. So what we do is create a system so that people who are buying assets or people who are dealing with the estate to deal with claims or get paid debts know who to deal with. That allows business to continue on fairly normally. There's not a big diminution in value of assets because you die. Your assets retain the value because there's an organized system that the people who are going to buy them from you know that they're going to get, like with a piece of real property, good and insurable title in that property, not some sort of black market title. So probate's not all bad, but probate is the process of changing titles out of the deceased person's name, and along the way we got to pay the creditors. So it does some vital and essential things. So what are you doing? In this case, you remember John's will, it was simple. Oh, by the way, he has died now, yes. He's died, R.I.P. John Jones. So what's going to happen to his assets? They're going to go to Jane. So the probate process gives Jane the legal authority to transfer assets in John's name into her name. Most common thing is that real estate's purchased in a couple's names, and then one has died. Does the survivor have full control over that asset? No. Can they sell it and give insurable title without probate? No, they cannot. So she transfers the whole homestead to herself through the probate process, then she can control it. She can refinance it, mortgage it, sell it, whatever she wants. What else happens in probate? Well, you have to have a forum to resolve disputes. You know, you have to have, it's called a last will and testament, because it's got to be the last one. You have to be dead, and we can have disputes over who's got the last will. So if there's going to be a fight over who's going to have the authority to change the assets, we have to have the fight then and there. So it's a forum to resolve the disputes. Most probates far and away are undisputed, but it does happen. We have to pay the creditors, we potentially have to inventory and appraise the assets, and finally what we really want is to distribute the assets of the estate to the people that we want to get them.
I have a question.
Absolutely.
A while ago you said that if, you know, they had, each had a car, and his car was in his name and hers, and he died, and let's say she couldn't afford his vehicle, but it was in his name, would she be responsible for the creditor with that vehicle because it wasn't in her name?
If the decedent has a negative balance sheet, they're got more debts than assets, you walk away from the assets. So that happens every once in a while. Someone will come in and Dad had $50,000 of credit card debt and he has $5,000 in the bank, and they want to know, how can I get to that $5,000? I said, well, you can. Well, you can, but you're going to spend it paying the creditors. They're going to get, in effect, 10 cents on the dollar. So you don't inherit debts, but you don't get the asset without the debt. So sometimes with vehicles, they're underwater. I mean, the vehicle itself is underwater, and we kind of leave it parked on the side of the road in plain view, and they come and repo it, and that's the end of the issue with it. And so you don't necessarily have to inherit the debt, but as a general rule, you can't take the assets and not pay the debts. So, problems with probate. As I said, Texas is a good probate law state. You do it wrong, you have inadequate, outdated documents or no documents, you're going to have a significant amount of fees. Court fees, publication bond fees, executor fees. Now there's a misconception that if you go through probate, you're going to lose a certain fixed percentage of your estate. I understand that is true in some states. It is not true in Texas. So your executor or administrator can charge a fee, usually in like a couple's situation. The survivor doesn't charge any executor fee, and there's nothing automatic. Neither does the lawyer get charged as a percentage, get paid as a percentage of the estate. And frankly, it is no more complex for us to probate a well-drafted will on a $5 million estate as a $50,000 estate. It is the same process. So you're not charged as a percentage of the estate, either by the executor or the attorney. But costs are a concern. Delay is a concern. Let me give you an example, even with a will, how you can have significant delay. A state that I handled some years ago, the gentleman died, and he had a property, I think it was in Garland. It was not very large. It was probably worth about $60,000. He had a will. He didn't have any children. He wanted to leave his property to his nieces and nephews, and he appointed his brothers as the executors. This gentleman lived to be 98. His brothers weren't around anymore, and he had updated his will for like 25 years. So there was no executor named in the will. Okay, if there's no executor, he didn't pick who to trust. So if you don't have anybody named in the will who you trust, what happens? The court will appoint someone to run the estate, but it's back to Mother May I, and it's expensive. And I appointed our client, one of the nieces, to be Mother May I. We could have smoothed this out if everybody agreed she could have been done this without court supervision. We called the various nieces and nephews, and many of them told us, "Don't bother me." That's literally what they said, "Don't bother me." Wouldn't sign a form. Okay, we went and probated the estate. The fees and expenses were about $12,000 to sell a $60,000 house. That's ridiculous. And
Was she considered a guardianship when you appointed her?
no, she's an administrator of the
Administrator,
estate. To be
okay.
technically, she's the administrator with will annexed. So there's a will, the will controls who gets the property, but who runs the estate is very much like a guardianship. And she's having to ask for supervision to do everything, do an accounting, post a bond, do all of this stuff. Now, so we then sell the property, we net about $48,000 after expenses. Still, the nieces and nephews are going to get the property, and we called them up at this point. The people who said, don't bother us, and said, well, now we have a check for you. And they said, when can I sign? When can I get it? Then they were all really smiling and cooperative. But if they'd been smiling and cooperative a year and a half before, we would avoid a lot of expense and a very long process, because administrations, court-dependent administrations of estate is slow and expensive. So we definitely want to do something to minimize that. Second issue with probate, this concerns some people. It doesn't concern everybody. It is a public forum. The probate courts are open to anybody. Most records of our courts are now electronic. They are available for searching. You don't even have to go to the courthouse. Now, our probate clerks have walled off some of the assets, some of the information, including asset information, from electronic search, but a will and everything at the courthouse can be obtained. So they say, I can't electronically download an inventory on an estate where I'm not the attorney. Okay? Sometimes I'm interested in an estate for legal reasons, for valid reasons, for someone's made an inquiry. So what do I have to do then? I have to actually go all the way down to the courthouse, boo-hoo-hoo, and say, I want the file on case number 123815.2. And they give me, and I said, what do you want out of it? They said, give me the inventory. They print it out. They don't ask me who I am. I'm entitled to it. It's a public record. So it's a concern, usually if the person you're thinking of leaving your property to is vulnerable to fraud. It gives them enough information to target that person for a scheme to defraud. It does not give them enough information to do like steal your assets, to go to the bank and get your assets. That's not the risk. So it is revealing enough about yourself or your survivor's situation that it may be an issue. So probate can be expensive, probate can be an open court record, and then we want to avoid an issue of multiple probates. Why would you have multiple probates? Because you had so much fun the first time, right?
Own property in different states.
You own property. And by property in this case, we mean real property, land or mineral interest. A Texas executor, that's the person who's running the estate, has the authority to deal with personal property everywhere. We have this legal fiction that if you have a Chase Manhattan bank account, that it's really domiciled where you are, and so a Texas executor can deal with it. Real property, it's wherever it is. So my Texas executor, when I probate the will, doesn't have the ability to transfer land or mineral interest in another state like Pennsylvania. And I'll tell you this, Texas has really good probate laws. Oklahoma, to do what we call an ancillary probate, that's the second probate, is more expensive than to do the full Texas probate. Louisiana is more expensive than that, and they don't even call it probate because they're Cajun, and it's just really weird. Florida is a bad place to die. Ohio is really expensive, and California is really certifiably crazy. It is so crazy that when I talk to California estate planning attorneys, and they only think in terms of living trust to avoid probate. They always avoid probate because probate in California is unreasonable. So you obviously don't want to go there for an ancillary probate. So we got to make sure if you own property in another state that we have planned for it in a way to avoid multiple probates. So in summary, the disadvantages of probate is it's potentially expensive. You got to do it right. It can be time consuming. Public, if that's an issue for you and you want to avoid multiple probates. So you must, in your planning, address these problems. Now let's talk a little bit about taxes. These are generally the taxes we pay during life: income taxes, property taxes, sales taxes. Now, how are taxes impacted by estate planning? Usually in two significant ways. IRAs, 401ks, 403bs are deferred taxable accounts. That means that we aren't being taxed on that money as it grows. We're taxed when it comes out. If you leave the property to somebody, somebody is going to pay the income tax on that asset. You're not avoiding income taxes. I know of no scheme through death to avoid income taxes. You're going to pay them. Okay? So the question is, in part of your asset estate planning, are you drawing out the assets from the right source at the right time? In other words, are you increasing, and here's the potential increase in rates, if you give an asset that has trapped income taxes in it to someone who's potentially in a higher income tax bracket. I remember when we first started with IRAs in the 80s, they were a new thing if they were brand new, but they were still really green when I was in business school. And the thinking was, well, when people retire, they have lower income, and so that's when they can draw it out and they'll be taxed at a lower rate. And the reality has not been true for most people. And you find most people are trying to take out only the minimum out of their taxable accounts, the required minimum distribution that they're required to take after they reach 70 and a half, right? Okay. So they, but are they passing that on to someone who's going to pay a higher tax or lower tax? As a family, do you want to pay higher taxes or lower taxes? So this is a consideration. Oh, one other thing. Capital gains. Now, here is a way to game the tax man. There actually is one benefit of dying. If you have an asset that is appreciated in value, I'll give you two examples that are common. You buy shares of stock that then grow tremendously in value. You were really astute and you bought Apple when they kicked Steve Jobs out, and you held it when he came back and the company took off, and you've made 100,000% on your investment, but you haven't sold the share, you still have it. You have a trapped capital gain. There's appreciation of that asset. If you die and you haven't sold that asset, your heirs get a step up in basis, meaning they're treated as they bought it at the value of date of death. That trapped capital gain goes poof. So what do you not want to do when you're nearing the end of your life? Sell those assets, because then you're paying taxes that potentially were going to go poof, poof. And a lot of people have a very strong desire to tidy up their estate. And I just had a family member do this, and it was painful to see it happen. He wanted to tidy up things. He knew he was dying, and so he started selling his rental properties. And he incurred capital gains. And it would have totally been avoided if he had just held on to it. So there is a tax that can be totally avoided. So tax planning and estate planning go together. Another type of taxes is gift tax. Now, first of all, someone who receives a gift doesn't ever pay tax. That's a common misconception, that if someone gives me a gift, I'm going to pay taxes on it. It's always good to be the receiver. You don't pay taxes in the case of a gift. There's something called the annual exclusion that causes a lot of confusion. The annual exclusion is the amount of money that you can gift to somebody in a year and not report it. Okay? It's a non-reportable gift, which is different from being a non-taxable gift. Non-reportable means you don't have to tell the IRS about it, and there's very practical reasons. I mean, if you give out $100 at Christmas to all your children, you don't want to have to report $100 gifts. That's not practical. So there's a limit. Right now it's $14,000. That is the annual exclusion. Does that mean if you give $15,000, you pay gift tax? No. It means you have to report the gift, and gift tax is really part of one tax called the estate, gift, and generation skipping tax. It's all one tax. Here's the bad news. The tax rate is 40%. It's confiscatory. It is a tremendously high tax rate. Here's the really good news. The first $5.49 million is excluded from tax. So this whole issue about gift taxing and reporting is just a bunch of paper shuffling unless you as an individual have more than 5.49 million, or as a couple just a shade less than $11 million. So this really has become a problem of the 0.1% that they have this problem. If it is your problem, there is planning that needs to be done, but that's really beyond the scope of what we're talking about today. The good news is that most of us don't have this problem, and we might have to do some planning if you're approaching the threshold, and that in the reasonable near future, it's a possibility that you can be exceeding that, and there are a whole range of planning opportunities that may work for you to avoid or limit taxes. The Generation Skipping Trust is a whole nother lecture that only an egghead would enjoy, so let's not go there, but it's not a problem. Okay, so we're back to our situation with John and Jane. Remember, they had $700,000. John dies, he leaves everything to Jane. She gets $700,000. She's gone through probate, the assets are hers. What happens from there? On average, the surviving spouse lives 7 years. That's the average. So it's not like John dies one day and Jane dies the next way. That's not the way it usually works. We can assume that Jane either grows her money or spends it all. We wouldn't have a discussion worth going on if she spent it all or wasted all her money. So we're going to assume that she has maintained her $700,000. Then what happens? Well, what do we do after Jane dies? Now remember, John had a will. They went and got wills at the same time, and John's will said, when I die, everything to Jane, then to my children. So it's all taken care of, right? We probated John's will. You don't think so? No, now you have to probate Jane's will, because a will acts to transfer assets once. It's a one-step device. So it said, if Jane survives me, the assets to Jane. The rest of that stuff about if Jane doesn't survive me didn't apply. So that will was probated, the assets become Jane's. Now John's will is moot. So Jane has to probate her will. Again, if she did it wrong, you're going to have all the problems that we talked about, excessive expenses and everything like that. If she did it right, it's not that big a deal. What if Jane becomes incapacitated after John dies? Well, she has the same problem that John had. She's going to need a guardian. And so you just keep compounding these problems. And now who's going to be her guardian? Well, it's going to be a battle probably between Susan and Timmy. And that can sometimes, generally when guardianships get ugly, it's on the second spouse or the second family member, and the children don't get along. And they find a way to war. And guardianship fights in that regard can be extraordinarily nasty. Another issue is, what if, you remember Susan? We like Susan. Susan was responsible, but then she married this guy named Bruno. And here's Bruno's idea of financial planning. You buy some gym equipment and go to Vegas. That's his idea of financial planning. And so we are concerned that will our children be pressured out of their inheritance even if they are responsible? Jane has nothing like that in her will. It's all just going to go to Susan and Timmy. If Timmy has a drug problem, he's going to snort it away. If Bruno is overbearing, he's going to get control of the assets. Literally, an inheritance is separate property. But if you commingle it with your community property and you can't tell who's whose anymore, and then Susan wants to divorce Bruno, she's going to have a hard time proving that that inheritance stayed distinct and that it's her separate property and not subject to division in the divorce. So you want to plan for the Brunos. So Jane passes away, but in this case, we had a simple estate. It gets distributed 50-50. Hopefully we don't have all the problems that we talked about, but all of the issues that we dealt with, the expenses, the multiple probates, the public records, all of that is available once again with Jane. This is not a ridiculous scenario of what probate can cost. On the low end, You can have 0 fees, minor court costs, waive bond, and have reasonable attorney fees with a well-drafted will, which is why I say probate is not terrible in Texas. It really isn't. But if you have court-supervised administration, a relatively complex estate, this number is probably on the low side. I didn't give you the horror story. That is what not planning can cost you. So then we have taxes. You didn't think about the taxes, and so you left money to Susan and Timmy but it was it was all in the 401k, 401(k) IRA, those deferred taxation accounts. And so what happens? Let's say $300,000 they inherit an IRA. Do they really get $300,000? No, they're going to get the net of that after taxes. So was that a smart decision? Well, it depends on whose tax rates were involved. So there's a loss of that income. So you look at all of this and you say, well, there must be a better alternative. And that's what we want to show you in the second half of the presentation. We're going to take a break now. You have an opportunity now to sign up for a free consultation. There are the rules for that. I'll talk about this a little bit more at the end. We'll take about 8 minutes, 10 minutes, somewhere in there. Get yourself a drink, stretch your legs, and then come back and we'll talk about the happier side of this, which is positive ways to handle this so you don't go through all of this. Thank you.